My name is Halika Sayed, and I am an intern at Khatana's Law Chamber.
Hello everyone, my name is Amina Zara and I'm also an intern at Khatana's Law Chamber. Today we are honored to have with us Mr. Ali Salimi, who is a distinguished expert in trademark law.
With an LLM in intellectual property rights from the University of California, Berkeley School of Law, and a specialization in company and commercial law from the University of London, Mr. Salimi brings a robust academic background to the legal field. He will be sharing his insights and expertise on the latest developments and trends in this dynamic field.
Assalamu alaikum, ladies and gentlemen. Thank you for the introduction, Halika and Amina. I am really looking forward to share my knowledge and learn from all the participants over here. Ji. Halika, do you have any question or should I
Sir,
just
I
give
would start
you...
with the first basic question. Can you
Please
please explain what trademark law actually entails?
As you might all know that this is a continuation of our earlier series of webinars. We have already discussed what trademarks and copyrights are, but today we are going to shed some light on the current trends in the trademark law. And for those of you who haven't joined the previous series of my webinars, or those of you who are not well aware of what trademark entails, let me just explain it to you very briefly and concisely without going into the technical nuances and the details. So basically, Halika and my viewers, trademark protects the logo, or as the name suggests, the mark of your product. Okay, so any business, for that matter, whether it's a fast-moving consumer product or whether it's a service, we see that they have their logos or their identity. For example, McDonald's, you can see that they have an M, okay, a yellow colored, differently styled M, which is synonymous with McDonald's. So it basically, whatever your logo, whatever the logo of your business is, if you try to protect it and if you want its intellectual property in terms of your logo not being used by anyone else or copied by anyone else, that is called trademark. And intellectual property rights denotes that your logo has to be safeguarded so that not any other average Joe could basically use your intellectual property rights and pass off as their own. So in short, that is the definition of a trademark right.
All right, thank you, sir. So for the next question, could you elaborate on how effective is the current system of protecting trademarks and geographical indications against infringement?
Okay. So Amina has now pointed out towards geographical indications, and for those of my audience who are not well aware of geographical indications, let me just explain what they are. So, like trademark, geographical indications are basically a corollary, or you can say an offshoot of trademark protection. So, in Pakistan, this protection came in 2020 in 2020 in a form of GI protection ordinance of 2020. So there is a history behind how geographical GI protection came in Pakistan, because there was a very interesting case law that my audience might be aware of. If not, let me just explain what it was. So during the period of the erstwhile government, there was an issue. Pakistan was fighting with India in terms of a commercial avenue. So there is a rice called basmati rice, which is very popular all around the world, especially in the European countries. So India tried to get its GI tag. So what GI tag is, let me just explain. First, let me just give you a brief background. So this specific rice was produced in the Punjab area of India and Pakistan. So they try to exclusively get economical benefits out of this geotagging by stating that this is only produced in India and only India should have its geographical tagging. So Pakistan filed an application before the European Union, and when Pakistan did that, it came to fore that Pakistan had no local legislation in terms of protecting geographical indications. Pakistan had relevant trademark laws, but there was dearth of any legal mechanism for protecting geographical indication. So Pakistan had to legislate on it so that they could fight this case at EU. So that was very important for you guys to know. Now let me just explain what geographical indications are. So geographical indications basically it is a protection of the geographical identity of a product or a service that is basically synonymous with that region. As I just explained, basmati rice is usually produced in India and Pakistan, and now there are different strains which are being manufactured in Mexico. Even United States is trying to produce that in Texas, in one of their states. And basically, there are a lot of other countries which are trying to produce a strain of that basmati rice. So any product or anything that is specifically identified as a local produce of that region, that is called geographical indications. And when you try to get that protection, that is protected under GI, which is geographical indication, and it's called GI tagging. So for instance, if you try to, let me give you another example, since it's the season of fruits of king of the fruits that is called the mango. If someone tries to manufacture mangoes in Multan and they want to export it all over the world, or even export it in Pakistan, and they want to label it as Multani alms or Multani mangoes, so it would be really important for them and really helpful for them to have a geographical tagging of that product so that nobody else could export that product. And there are a lot of tiers, Amna and Halika and all my viewers over here. So basically, in geographical tagging, it's not the producer or the farmer which owns that, right? It is basically the country which owns that right. For example, in Pakistan, if you are trying to sell Multani mangoes or Swat apples, so it's not the manufacturer who will get that right. It is basically that body or a state body or a public body which will own that right, because the right basically lies with the country. The manufacturer, the supplier, or anyone in the supply chain basically becomes the licensee to basically glean the economical benefits of that product. Because I think it will make more sense, because if you individually give those right to each and every person or a person in Pakistan, that would create confusion. So basically, geographical indications protect your product, but the tagging is basically owned by the relevant public body of that country. The relevant producer or anyone in the supply chain I have explained, they are basically the licensees. So I hope I've been able to explain that. If you have any other follow-up questions, please feel free to ask me. Ji.
Sir, what are the most significant recent developments in trademark law in Pakistan, particularly with the introduction of the Geographical Indications Act?
So Halika, it's basically there are a lot of tiers to this aspect. Since in Pakistan, though GI is a offshoot, or you can say it's a province of trademark, but they both entirely protect different features. So basically, in under trademark protection, the most important update in Pakistan, since as you know that these intellectual property rights are always global in nature, you can't just encapsulate them into local protection. So first I will talk about the international scheme of things, then I'll come to the local scheme of things. So internationally, the foremost update in trademark law is basically the Madrid protocols, of which Pakistan is a signatory now, and I guess Pakistan became a signatory of it in I guess 2018. I'll just reconfirm it over here. So basically, what it entails is that anyone who has a trademark right in Pakistan can automatically glean that benefit in any other host country, which is basically a signatory of the Madrid protocols, and basically all majority countries of the world who are member of the World Trade Organization are part of that. So, for instance, if you have a brand, Halika or Amina, if you have any, it might be anything. It might be a clothing brand, it might be a software brand, anything. So if you have protection in Pakistan, you can automatically get protection in the host countries which are member of the Madrid protocols. Obviously, you have to file an application, which is a single application under those Madrid protocols, which is filed with the World Intellectual Property Organization. And if you do that, you can automatically get the protection in Spain, France, or UK, or whatever. So if you are a producer in Pakistan, you have a clothing brand, if you have an apparel, if you have a company which makes clothes or any apparel, so if you are an exporter and you have your trademark protection in Pakistan, so you can also have protection in the countries where you actually export your product. So if there are any circumstances in which you think that your product is being infringed, it will automatically be enforced. Let me give you an example. So before that, before giving you an example, there is still an issue. Pakistani products do get protection abroad, but international products do not automatically get protection in Pakistan. So for that, Pakistan has to make some legislation, since Pakistan is a dualistic state. Any international treaty which we sign does not automatically become part of the Pakistani law as long as we don't legislate on it. So Pakistan has made some legislations in terms of protection of our trademark rights in the host countries, but vice versa, Pakistan has to make some legislation with regards to that. So, for instance, if I don't think so, Louis Vuitton is present in Pakistan. Halika and Amina, if you can educate me on that. I don't think so. Louis Vuitton is officially does not officially have a shop in Pakistan. Am I right?
I'm
The
not very
famous,
sure about that.
yeah, I don't think so. I'm pretty sure Pakistan does not. The three main cities of Pakistan, Karachi, Islamabad, and Lahore, they do not have any outlet of Louis Vuitton. So let's imagine that if any product of Louis Vuitton LV is basically infringed in Pakistan. If you go to I'll talk about Lahore. If you go to Shalmi, you will see a lot of clothes, caps, or bags which have logos of LV on it. So if someone is basically infringing their product, since Pakistan has not made adequate legislations in terms of protection of international trademark logos under the Madrid Protocol. There is another feature which I'll touch upon over here. There is another protection for international clients, which I'll explain it to you over here. So since there is a dearth of that legislation, so LV or CK or any other brand which is not officially operating in Pakistan, they cannot automatically enforce their rights in Pakistan. But there is another mechanism, the trademark ordinance in Pakistan. I guess it's section 24 or 26. One of my students, I guess a couple of my students from my LLM class, intellectual property LLM class, are participating over here. They can identify the actual section. It basically says that all international well-renowned brands are automatically protected in Pakistan. So they have to actually go to the court and explain that we are an internationally recognized brand and file an infringement suit in order to protect their trademark proprietary rights. Otherwise, again, summing it, if Pakistan legislates on makes further legislation in terms of the Madrid protocols, the international brands which do not have presence in Pakistan, they will automatically get recognition. But at this very moment, they do not have automatic recognition. They have to go to the court and explain that we are an internationally recognized brand, and only then they can convince the court and file an infringement suit for further proceedings. So that was my answer in terms of trademark. Now, let's park that aside and talk about GI protection, geographical indications protection. So your question, Amana, again, it was a two-part question. I'm repeating for my viewers over here. You particularly asked what are the recent trends in GI protection. Is that right, Amna? Am I?
Yes, sir, that's right.
I'm paraphrasing your question correctly. Okay. So under GI protection, as you know, that it's relatively a very new legislation in Pakistan, and not a lot of people know about this protection. And as I just said, that it's the state that owns the right. The manufacturer or the business persons involved in the supply chain are only the licensees which can glean that benefit in the export market. So I have seen that there is not a lot of trend in wherein the business community has opted for GI protection due to the same reason, the reason which was highlighted a while ago in terms of Madrid protocols. So Pakistan is still not officially a signatory of the Lisbon Agreement. So under the Lisbon Agreement, can you hear me? Is there a question? I thought somebody asked a question. Please mute your microphones. So as I'm saying, under the Lisbon, Pakistan is still not part of the Lisbon Agreement. So at this very moment, Pakistani GI geolocations or GI tagging is protected in the host countries abroad, but the international GI protections are not automatically protected in Pakistan due to the fact that Pakistan is not officially a part of the Lisbon Agreement, and there is not any legislation in terms of that. So there is a dearth in that area. So hopefully, people at the helm of affair would realize the importance of this, especially in light of the basmati rice issue, which we had with India. Because there is a lot of, since Pakistan is an agro-based economy, so there is a lot of avenue in terms of economical viability, and Pakistan could earn a lot of foreign revenue if we get this protection straightened out. So that is the latest in terms of GI protection. Anything else? Do you have any other question, Anna?
Sir, I actually had one question. Could you please discuss the key challenges in the trademark registration process in Pakistan?
So you're asking about the key elements, am I right? Or the problems? Can you just
The
repeat
key
that?
challenges.
Oh, so the key challenges. So we live in Pakistan. Every day is a challenge. Even going out of your house to your home is a challenge. I see a person laughing over here, Abdullah. So I think you mirror my thoughts. So yes, in Pakistan, there are a few very major issues in terms of trademark protection. One being the sheer time it takes and basically the bureaucratic uphold at the IPO office, especially the trademark office. So, for instance, if you file a search report, you have to officially file it through a bank challan, okay? And the bank challan takes a couple of days. It goes to the IPO office, and there is, I think the official statutory time under the rules and regulations is 15 days. So for 15 days, if a client comes to you and he wants an opinion, usually in how the international market works, 15 days is a lot of time. In 15 days, a cargo from America reaches Australia. So it becomes very cumbersome. So the filing process is very cumbersome. They have opted for online filing of trademarks, but still there are some teething issues like any other new feature that being added in the Pakistani legal system. So the online protections, the online filing still has some teething issues. So that is basically the key issue. And there is also a very other major issue So if you file there are certain objections when you file your TN, which is basically automatically you always, no matter what you do get some objections from the trademark office, and there is a statutory period for filing those objections or replying to that department. So the thing is, whenever that objections are basically raised by the department, they are sent to the counsel. They are sent to the lawyer who is basically protecting the interest of the client. They are not sent to the client themselves. So at times, what happens is that, for instance, your deadline for filing the reply of the objection is, for instance, today. And you will get that letter a day prior, and it is virtually impossible to make and file a reply within 1 day, especially in light of the bureaucratic hurdle that I just explained in terms of bank challan and other things. So we see that there is a lot of lag and it has to be expedited. So WIPO, World Intellectual Property Organization, has some key SOPs, and this issue has been raised internationally. And I was a participant at one of the seminars in Pakistan in terms of intellectual property rights. And amongst the panelists, there were members from the IPO, Intellectual Property Organization, and the trademark department. And I raised that issue with them. So hopefully it will get sorted in the near future.
Sir, you mentioned the online filing system. Is that a good recent development? Is there any progress from that?
I think it is a step in the right direction. So the thing is, now you have to be a licensed person to file online trademarks. So yes, it is a very welcoming addition in our scheme of things over here in Pakistan. But as you know, there are always hurdles when you guys might know that when SECP, I think, was the first quasi judicial body in Pakistan. I think back in 2008 or 10, it introduced electronic e-filing for registration, for registering a company. So they also had teething issues, and now many of those issues are sorted. So I think it will get better in time. It's just been an year or so since this online mechanism has started, and there are very well-informed videos, tutorials on ipo.gov.pk on how to file those trademark applications. So I hope in the near future it becomes with time, all those teething issues would go away and it will become better. Any question?
Sir, are there any other notable recent trademark infringement cases?
So I think let's discuss a few of those. In Pakistan, there are a lot of trademark is a very robust area in Pakistan in terms of litigation. We'll touch upon patent and copyrights. I've already discussed about copyrights. Copyrights, there are a lot of exceptions in copyright law. As I've recently seen, Halika, that you've made a small video on it. It was very very well crafted, and it was very informative. So as you know that there are a lot of exceptions in the copyrights. Trademark has is a very robust system in terms of litigation. So I think we would be needing at least 2 webinars covering those recent judgments. But I think let's touch upon a few of the judgments in terms of GI protection, the international judgments in terms of GI protection, because as you know, the topic over here is recent trends in trademark, and especially we are covering GI. So let me discuss a few in terms of GI, and then I'll also touch upon a few on one really important judgment in terms of trademark. So first, let's deal with GI. So I've discussed the Basmati issue with you, but let me just explain the importance of this case. So India basically tried to register its GI and wanted to export the Basmati rice as its own. And basically in Australia and in EU and in the United States. So Pakistan countered that in European Union, and Pakistan was successful in negating that. And previously, before this judgment, Pakistan was not able to export its rice internationally with the label of basmati. Pakistan did export rice, but Pakistan could not write basmati rice. And as you know, basmati is a very sought after sorted product all over the world. We used to export it to India, and India used to export it further, labeling it as basmati. So that was a very interesting case. And there is another very important case in terms of balsamic vinegar between Germany and Italy. It was also a very important case in the international commercial arena. So Germany tried to, in this case, let me just give you the name of the case so that if you guys are interested, you can search it up on WIPO, World Intellectual Property Organization's website. Halika, I think I sent that to you. Can you share the screen? Since you are the moderators, can you share the screen of that case if it's convenient for you? It's basically Aceto Balsamico di Modena. Halika, are you with me?
Sir, just a moment. I'm
No
looking through
issues.
it.
I'll explain. Just share it for the audience so the viewers can also have a look at it. I'm just delving deep into it. No issues at all. But I just wanted the people, my participants, to participate as well, and let's make it more engaging. So it would be more pertinent that you guys could share the screen as well.
So it was the
So,
basmati rice case, right?
Yes, that too, but I think we're done with that. I've explained it already. Can you share the Aceto Balsamico di Modena case summary? It's a 3-pager
Yes,
PDF.
got it, sir.
Can you share that? So a very eminent and hardworking student of mine just sent me a list of registered GIS of Pakistan. Let me just touch upon that, and we can take it further, and then we can discuss the issue between Italy and Germany. So let's first discuss the issue of Pakistan. My audience might be thinking that apart from basmati rice, what else is Pakistan tagged in terms of GI protection? So there's a very interesting list that I would like to share. So apart from basmati rice, Pakistan has the basmati rice is basically owned by TDAP, registration body. As I said, it's the state body which owns the right, and the people in the supply chain are just the licensees. So Trade Development Authority of Pakistan owns basmati. It started owning it since 21/1/2021. Hyderabadi bangles are being owned by Cultural Department of Sindh, and the ladies over here might know that it's also a very culturally important item in Pakistan, apparel. So it is owned by the Cultural Department of Sindh. So Kheda pink salt, again, it's a very important product. We have my audience will be really interested to know that we have a treaty with the state of Israel, which we don't even officially recognize, but we still have a treaty with them that even in case of war, we would not be stopping the supply of pink salt because it is used as a. Are you guys with me? So yeah. So since it's used as a religious custom in some of the religious customs. So pink salt is owned by the Kevda Mine Association, if I'm not wrong. Let me just double check. Yes, it's owned by the Pakistan Mineral Development Corporation, PMDC. And Sirgoda Kinnu is also owned by TDAP. Chaunsa mango is also owned by TDAP. Mangoes, all the variations of Sindri mango and other mangoes are being owned by TDAP. And there are again certain dates in Sindh and Balochistan. One is being Begum Jangi dates, which is owned by the Directorate General of Agriculture Research in Balochistan. So these are some of the items which are owned by Pakistan, and whenever they're exported abroad, no other country or no other organization could glean their right, and Pakistan is earning a lot of foreign exchange from these products. But these are just 10, these are just a dozen. So Pakistan has to do a lot in terms of protecting these rights. And I think it's the business community, the farmers, all the people, as I said, in the supply chain, who basically have to apply to these departments to get that right registered. So thank you, Farah. Farah, one of my students, my LLM student, has just shared that list with me. Now coming to the basically the cases. Halika, if you may just share the screen so that the audience could participate. So I'll just be short and precise how important GI tagging is. So there
Excuse
was
me,
a
sir. We're trying to share the
no,
screen,
no
but
issues,
there's
no
some
issues,
issue.
no issues, no issues. What we can do is we can, when we're uploading the video, we can edit it and we can share it in a form of slides. So there was a case in, again, in the European Union and the Trade Committee of the European Union. So over here, basically, there is the balsamic vinegar is basically a product of Italy. It has been introduced by Italy. It was really famous. It became really famous all over the world. So Germany also tried to manufacture and produce it, and they name it as Aceto Balsamico di Modena. Turn on my video. Hanji. So as I was explaining, so so guys, ladies and gentlemen, the issue in Pakistan, I'm explaining the case of GI protection, and since it's a very recent development in Pakistan, the law came in 2020, the protection started in 2021. There is hardly a dozen items in the list under protection by the Pakistani government. It's basically all agro-based products. So, and Pakistan has been, and again, this came to light and came to fore due to our issue with India in terms of basmati rice, and that's the only case which Pakistan has contested in at the international forums. So there is a lot of dearth in that issue, and basically the case law is already always international internationally contested before these forums. It's never a Pakistani court which will take cognizance, because as I have explained, it's the country, it's the host country that owns the GI identification, not the manufacturer. The supply, the people in the supply chain are just the licensees, which obviously do glean that benefit. Okay, so with that knowledge in mind, let's go further. Some of you might be wondering, why are we discussing a case of two European countries? How is it important? So with that in mind, I'm explaining the case. So there's a case between Germany and Italy. So over here, Germany tried to manufacture some products based in Germany, produced in Germany, and they were a derivative of basically balsamic vinegar. And balsamic vinegar is basically was made popular in the world by Italy. It was made in a region called Modena region. So the label of that product is very, very complicated. My German is not that good. I would not be naming that product for the benefit of the participants over here. But basically, what it said, I'm loosely translating that. It basically said that the vinegar brewed, matured in wooden barrels, German balsamic vinegar, traditionally naturally cloudy, made from Baden wines. So it's also, wine is basically made from it is allocated the region that where the basically uh, the fruit is produced, that is very important. So over here there was an issue between Italy and Germany, that since the German product used the name of Modena, so they are basically trying to show it to the world that it's basically made in Modena. So this case was adjudicated at the EU, and after a lot of discussion and adjudication, the court basically said that we can't just isolate one word. They used the word Moderna, but we will see the whole product and the whole labeling. So you can't just pick and choose and isolate one word and say that since they used Moderna and they're trying to show that it was made in Moderna and Moderna is in Italy. They said that basically the label clearly said that it's a German balsamic vinegar, traditionally colored and made from Baden wines, and Baden is in Germany. So there is no confusion on that end, and we can't disallow Germany to label and produce this product and export it to the world, because they are not transgressing on the Italian government's right in terms of labeling that. So I hope you guys got an idea why this basically litigation and this matter are very important internationally. And again, there is another really important case of a French champagne, which was again tried to be protected in the United States. Basically, the French company tried to protect its GI protection in the USA, and it's a very, very interesting case. I would really want you guys to have a look at it. And if you guys want, I can just share the link. So just give me a second. I'll just share the link of this case, and I'll just briefly explain it to you, and you guys can later on just have a read. So let me just go to the messages. G. So I've just like written it down over here. So if you guys can't access it, kindly do let us know. We will share the whole details in future. So over here, in this case, the issue was also very similar. A French company basically tried to GI get GI protection of their wine in the United States. And in the United States, the law is such that can you guys hear me? Can you guys hear me? There seems to be a lag.
Yes, we can.
Well, okay. So over here, the issue was that the champagne was basically manufactured in California, and they used the techniques that were basically formalized in France. And again, the similar issue occurred that there is an association of champagne which came into light in the 1940s in the earlier Madrid Agreement. And over here, the issue was again very similar, that you can't use the name of our champagne, French champagne, and use those those rights in your country. But the American companies tried to basically justify that, and they basically said that during the World War One, the whole region where the champagne was produced and the grapes that were used in those champagne were completely obliterated, and all those were transferred to California, Napa Valley, near my university, UC Berkeley. And from then onwards, it was produced from California. And once the situation subsided, they were taken, all those shoots, those grape shoots were then shifted back to France after the war. And then again, they nurtured, and the production of those grapes for the wine continued. So they said that you can't get exclusive GI protection of that champagne, since it was even protected by California, and if it wasn't manufactured in US, all the people in the world wouldn't be drinking that champagne on this very date. So they got that protection in US on this basis. So it's a very interesting case. So you guys should really have a read. Again, the law is a bit layered and technical, but apart from that, it's very interesting. It's one of the most interesting cases in terms of GI protection. So that's that in terms of GI protection. If there is any question, I'll try to take that, and then I'll come to the very important recent judgments in trademark. Is there any other question?
So I actually had one question in mind. Are there any alternative dispute resolution methods available for trademark disputes? And if so, how effective are they?
So yeah, Amna, a very good question. You guys would be really surprised to know that WIPO, World Intellectual Property Organization, was the first and the foremost international body which basically introduced alternate dispute resolution, the mechanism of alternate dispute resolution. Since it emanates from commercial activity, as I've just explained, all the cases that I've just explained, they are related to agro-based products. And as you know, that if you spend time in the courts arguing, adjudicating your case, it becomes very cumbersome. So WIPO was the first and the foremost international body which introduced this feature of alternate dispute resolution. And as you might know, that all these cases that I'm discussing, there are some of those cases are being adjudicated by the international forums such as WIPO, World Intellectual Property Organization. It does not have a proper court setting, but still it adjudicates these matters. So I think I've answered your question. Anything else, Amina?
No, sir, that's good.
So again, Amna, following that question, participants, so you can't understand, I would really like to elaborate this. You can't understand intellectual property rights if you don't have an idea of how international law works, because since the world economy is not local, it's very global. So you do have to understand that there are different adjudicating bodies. For instance, if there is an issue in terms of European Union, if you are trading with Europe, and basically the European Union is the relevant body. So there is a committee over there where you apply and you adjudicate. There is an adjudication. At times it's a quasi-judicial body. At times it's a judicial body. At times you go to the uh, 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 international courts in Europe and at times you go to the World Trade Organization. Again, it depends. It again depends on what the clause you have in place in terms of your the agreements between the two countries, two internationally trading countries, or the protocols or the regimes that you have signed. As I have mentioned a few, the Lisbon Agreement and the basically the Madrid protocols when I was discussing trademarks laws. So I hope you are now aware of that. So if there is no other question, may I just continue with the updates in the trademark, Irina, or do you have any other question?
Sir, I do have another question. What best practices would you recommend for businesses to ensure their trademarks and geographical indications are well protected?
Okay, so best practices. So first and foremost, you have to apply to the IPO, Intellectual Property Organization, and you basically have to get that product protected. If you're in the supply chain, let's imagine you are basically a farmer. Again, we were discussing agro-based products, but it could be anything else. So taking that example, you have to go to the basically IPO is it works under the Ministry of Commerce. It used to work under the cabinet division, but now after recent amendments and the law of IPO, it is managed by the Commerce Ministry of Commerce. So you have to approach them and tell them that this product is very viable. It has an international market. Kindly designate a public body which will be the owner of this GI protection. As I've just told, that majority of the agro-based products are basically owned by TDAP, Trade Development Authority of Pakistan. Then when that ownership is being given to that body, you can apply to get to be the licensee. So first thing, and again, like trademark and like copyright and like patent, the tier is not that difficult. In trademark, copyright, or patent, you apply to the organization, they give you objections, you basically satisfy those objections, there is a public hearing, there's approximately an year or two worth of hassle with the quasi-judicial bodies where you basically fight out that I need this protection. In GI protection, this does not happen. Over here, the protection automatically, the ownership automatically goes to the government. You just apply to be the licensee. So I think it is the responsibility of the people in the commercial arena to approach to the relevant body and highlight it, because getting its protection is not that difficult. Okay, so I hope I've answered your question. As you would know that the official list on ipo.gov.pk just shows that there are only 12 products, mostly agro-based products, that have GI protection all over the world, and they're registered in Pakistan. I hope I answered the question, Amina.
Yes, sir.
G, is there any other question?
Sir, thank you
I
for
got a
your
question.
time.
G, Adil, do you want to ask something? You were leaning in.
Sir, I wanted to ask a question if possible.
G, Abdullah Jamshed.
Sir, regarding the agriculture process that we discussed so far,
Just
how
pause,
do
just
I
pause. For my viewers, you can also
there's
ask
no
questions in
background
Urdu. This is
noise?
not an exclusively an English webinar. So please feel free to ask questions in Urdu. So don't hesitate. Okay? Ji, बच्चे पूछें Abdullah. Whatever language you're comfortable in. Ji,
Thank you, sir.
please, you may
Sir, I
continue.
wanted to discuss regarding the agricultural point which आप discuss कर रहे थे पहले. How have IP laws evolved to protect the genetic resources in agriculture and biotechnology sectors
जी, जी,
worldwide
जी.
and in Pakistan as well due to the growth of this sector nowadays?
जी जी, आपका अच्छा सवाल है। ये सीड प्रोटेक्शन से आपके हवाले से आप पूछ रहे हैं। आप अगर ipo.gov.pk में जाएं और आप साइट मैप देखें तो सीड प्रोटेक्शन का भी कानून पाकिस्तान में आता है। इट्स एन ऑफशूट ऑफ, आई वुड से इट्स अ कॉलोनी ऑफ पैटेंट, इफ आई मे। फॉर इंस्टेंस, अब्दुल्ला जमशेद ने जो सवाल पूछा एंड वेयर ही इज हेडिंग टू इज दैट लेट्स इमेजिन पाकिस्तान मेक्स अ डेरिवेटिव ऑफ मैंगो और लेट्स से ऑरेंज, जिसको हम माल्टा कहते हैं, और सरगोदा के माल्टे बहुत मशहूर हैं, बट उनकी सीड होती है। एंड इंटरनेशनली सीडलेस प्रोड्यूस इज वेरी वेरी अट्रैक्टिव एंड इट अर्न्स यू मोर मनी। ठीक है, सो अगर पाकिस्तान ऐसी कोई डेरिवेटिव बनाता है या पाकिस्तान अपने कुछ सीड्स में, जैसा वीट मैक्सी पाक एक सीड होता था 1960s में, पाकिस्तान में आया था, यूएस ने हमें हेल्प की थी इस पे, 1950s में बल्कि आया था, जिससे जो यील्ड प्रोडक्शन है ऑफ वीट वो काफी ज्यादा बढ़ गई थी। और हमारी फैसलाबाद एग्रीकल्चर यूनिवर्सिटी इस पे बहुत ज्यादा काम करती है। ठीक है, यू मेक स्ट्रेन्स ऑफ सीड्स so that the yield is basically increased. So वो basically आप you play, it's an invention and you play around with the genealogy of that seed, if I must say. So it is an offshoot of patent, not ideally trademark, but yes, if you make a seed and label it as a Pakistani seed, तो बिल्कुल आप उसकी GI protection भी ले सकते हैं। बट जो वैसे सीड प्रोटेक्शन के कवानीन है वो पैटेंट से रिलेट करते हैं। सो अब्दुल्ला, आप एग्जैक्ट सवाल क्या पूछना चाह रहे थे? ये तो मैं इशू को डिस्कस कर रहा था ना कि क्या है, बट व्हाट एग्जैक्टली इज योर क्वेश्चन?
Sir, my main question was regarding the development of IP laws with regards to genetic resources in biotechnology and agriculture. That how have
वो
those
है, वो
laws
प्लांट
evolved with the
प्रोटेक्शन है,
times?
इट्स प्लांट प्रोटेक्शन है, बट वो 2018 में इट्स रिलेटिवली अ न्यू लॉ। और इंडस्ट्री के जो लोग हैं, जिसका मैंने आपको बताया, फैसलाबाद एग्रीकल्चर यूनिवर्सिटी, और कुछ जो लोग हैं, जिस तरह फॉर इंस्टेंस एक आपको कोविड में बड़ा एक चीज मशहूर हुई थी, इफ यू गाइस वुड नो, मेरी क्योंकि फील्ड है तो आई कीप टैब्स ऑन दिस। एक गार्लिक का सीड पाकिस्तान में इंट्रोड्यूस हुआ था। इट्स वो बेसिकली अफ्रीकन सीड, इट्स उसकी यील्ड होती थी। अब जो आप में से अगर कोई जमींदारा करता है तो आपको इस चीज की समझ आएगी, वो लाइक इतना बड़ा गार्लिक होता था। आपने गार्लिक देखा होगा खाने में, इतना इतना से होते हैं। ठीक है, वो काफी बड़े साइज का गार्लिक था। ठीक है, उसको G6 G18 या इस तरह कुछ बोलते थे उस गार्लिक को। अभी भी आपको शायद बाजार में कहीं मिल जाए। वो पाकिस्तान में लोगों ने लगाया और बहुत उससे पैसे बनाए। वो भी बड़ा एक्सपेंसिव था। सो वो अगर आप लगाते हैं, यस, तो अगर आप उसकी सीड प्रोटेक्शन में प्रोटेक्शन लेते हैं और वो आपको एक्सक्लूसिव राइट मिल जाता है तो बिल्कुल आप कर सकते हैं। और वो भी, बट यही है कि आपकी जो बॉडीज लाइक GI प्रोटेक्शन, वो आपको उसका लाइसेंस मिल जाता है। वो कोई पाकिस्तान की पब्लिक या क्वाज़ाई जो पाकिस्तान की गवर्नमेंट फंक्शनरी है उसको उसकी ओनरशिप देते हैं। किसी अगर एक बंदे को दे देंगे तो वो फिर देखो, देयर हैज टू बी अ बैलेंस, यू कांट मोनोपोलाइज दैट। देखो आप इन चीजों को समझो, इंटेलेक्चुअल प्रॉपर्टी में आपको राइट दिया जाता है, एक स्पेसिफिक टाइम पीरियड के लिए दिया जाता है किसी भी चीज में, ख्वाह वो पैटेंट हो, ट्रेडमार्क हो, कॉपीराइट हो, आपकी कोई भी चीज हो, उसमें एक टाइम पीरियड के लिए आपको कहा जाता है कि आपका राइट आपने लिया है, आप इसको इस्तेमाल करें। लेकिन उस पर एब्सोल्यूट मोनोपोली आपको नहीं दी जाती, क्योंकि अगर आपको एब्सोल्यूट मोनोपोली दी जाए तो फिर क्या, खाना पीना या सीड और ये सारी चीजें तो कोई भी ना कर सके ना। इसलिए जहां तक जीआई प्रोटेक्शन की बात है और सीड प्रोटेक्शन की बात है, इसलिए वो स्टेट को ओनरशिप मिलती है और आप उसके लाइसेंसी होते हैं। गुड क्वेश्चन अब्दुल्ला, आई होप आई आंसर्ड द क्वेश्चन।
Perfect, sir.
Thank
Thank
you.
you so much.
Sir, I had
I'm
a
good।
question.
जी जी
Sir,
जी जी,
am I
आदो
audible to you?
जी जी, you're loud and clear।
Sir, as SECP is handling the complaints and issues related to IPO laws, then what is the need of IP tribunal in Pakistan?
आपने अच्छा सवाल पूछा, बट एससीसीपी की क्यों आपने बात की? एससीसीपी में क्या आईपीओ के हवाले से चल रहा है? अगर वो तो कंपनी के हवाले से एससीसीपी,
Sir,
तो कंपनी 1997 का जो एससीसीपी का एक्ट है और जो कंपनीज एक्ट है हमारा लेटेस्ट, उसमें तो बेसिकली इट्स अ बॉडी विच रेगुलेट्स कंपनीज। तो आईपीओ से रिलेटेड आप क्या क्या पूछना चाह रहे हो? अगर कोई
sir,
कंपनी है।
SECP,
बोलो
if we
बोलो।
talk about registering, sir, अगर हम लोग बात करें registration of trademark की,
हम्म
so SECP is the body to register it in
हम्म
Pakistan.
हम्म
Similarly, if we had a dispute related to copyright and some other dispute similar to it, then we had to go towards IP tribunal. Then what is the
बिल्कुल
relationship
ऐसे
between both of them?
आईपी ट्राइब्यूनल एंड एससीसीपी।
Yes, sir.
देखिए वो तब हो सकती है, अगेन आई एम जस्ट थिंकिंग आउट लाउड, मैंने वैसे कोई देखी तो नहीं। वो ये हो सकती है अगर कोई कंपनी हो, लेट्स इमेजिन, और कंपनी इन्फ्रिंज कर रही हो किसी का प्रोडक्ट। बल्कि इस पे भी मैं आते हैं, आपने जो सवाल पूछा, एक अभी ये केस भी पाकिस्तान में बड़ा एक मशहूर केस है। अभी रिसेंटली हाई कोर्ट में उसकी जजमेंट आई है। मेरे क्लास फेलोज ने वो आर्ग्यू किया दोनों साइड से, फ्रॉम बर्कली, पेप्सी और मीजान का। ठीक है, सो अगर वो दोनों कंपनीज हैं, वो कंपनी इन्फ्रिंज कर रही हैं और कुछ मसला क्रिएट कर रही हैं, तो आप आईपीओ जो है वो एससीसीपी से, आईपी ट्राइब्यूनल जो है वो एससीसीपी को, क्योंकि एससीसीपी रेगुलेट करती है कंपनीज को, वो उनसे इंफॉर्मेशन मंगवा सकती है। वो कोई भी गवर्नमेंट बॉडी से आपका कोई भी कोर्ट इंफॉर्मेशन मंगवा सकती है। मैक्सिमम ये है, बाकी तो मेरा नहीं ख्याल एससीसीपी का कोई लेना देना। हाँ, कंपटीशन कमीशन का देयर इज एन ओवरलैप, तीन डिपार्टमेंट्स का चीजों का बहुत ज्यादा ओवरलैप है। उनमें से जो एक है वो बेसिकली आपका ये आईपीओ है, जो आपकी इंटेलेक्चुअल प्रॉपर्टी रजिस्टर करता है। अभी हम ट्रेडमार्क, स्पेसिफिकली ट्रेडमार्क की बात कर रहे हैं। दूसरा इदारा जो है वो डिसेप्टिव मार्केटिंग को डील करता है। उसमें भी अगर आपको प्रोडक्ट इन्फ्रिंज कर रहे हो किसी का, सो वो देयर आर जजमेंट्स विच बेसिकली से राइट और रॉन्ग, आई वोंट गो इनटू दोज डिटेल्स। तो वो कहता है कि जी हम डिसेप्टिव मार्केटिंग जो है वो एंटी कंपेटिटरी प्रैक्टिस है और वो कंपटीशन कमीशन देखेगा। ठीक है, आफ्टर द 18th अमेंडमेंट इन 2010, हमारे यहाँ कंपटीशन कमीशन का जो अदारा है वो बहुत एक रोबस्ट अदारा है जो एंटी कंपेटिटरी प्रैक्टिसेस देखते हैं। और उधर 94 या 96 शायद सेक्शन है जो बात करता है कि डिसेप्टिव मार्केटिंग भी हम लोग देखेंगे। और डिसेप्टिव मार्केटिंग, इट्स इट ओवरलैप्स विद इन्फ्रिंजमेंट। ठीक है, कि अगर किसी का आप प्रोडक्ट है और वो मैं उसको मार्केट कर रहा हूँ और दिखा रहा हूँ और सिमिलर है, डिसेप्टिवली सिमिलर, और डिसेप्टिव सिमिलर बेसिकली टेस्ट है इन्फ्रिंजमेंट का ट्रेडमार्क लॉज में, तो वो हम भी कॉग्निजेंस ले सकते हैं। इसी तरह कस्टम है, कस्टम एक्ट 1959 का है, और हमारे ट्रेडमार्क के कानून में भी एक्चुअली देयर आर सेक्शंस जिधर लिखा हुआ है कि जहां इंफ्रिंजमेंट होगी किसी पोर्ट में, ड्राई पोर्ट में, एयरपोर्ट में या शिपिंग पोर्ट में, तो कस्टम्स के पास अथॉरिटी है कि उसको सीज और डिस्ट्रॉय कर सकते हैं। ठीक है, खुद कर सकते हैं उनको कुछ सर्कमस्टांसेस में, अगेन विद द कैविएट, इन सर्टेन सर्कमस्टांसेस आपको डायरेक्ट आईपी ट्राइब्यूनल जाना भी नहीं है, ऑर्डर भी नहीं लेने की जरूरत। ठीक है, देयर आर सर्टेन एसआरओज जो कि आपको कहते हैं कि आप सिर्फ आपने अप्लाई करना और बताना है जी फलाने पोर्ट पे, फॉर इंस्टेंस जी कोलगेट की सिमिलर, कोलमेट की और सिमिलर डब्बे की टूथपेस्टें जी मैंने कहीं देखी हैं पोर्ट में बड़ी हुई, आप यू जस्ट हैव टू इन्फॉर्म देम। ठीक है। और कोलगेट मैन्युफैक्चर, पाम ऑलिव बेसिकली कोलगेट बनाते हैं, वो उनको बताएगा तो वो जाके सीज, कोई कोर्ट का आपको ऑर्डर शॉर्डर नहीं चाहिए, कोई कुछ नहीं चाहिए, कस्टमर ऑफिसर्स खुद जाके वो सीज एंड डिस्ट्रॉय कर सकते हैं, ठीक है। इसी तरह कुछ प्रोडक्ट्स हैं जिसमें से आपके ब्यूटी ब्यूटी प्रोडक्ट्स आ जाते हैं, और आपके कोई खाने पीने की अशिया जिसमें दूध वगैरह आ जाता है बच्चों का, एंड कन्फेक्शनरी आइटम्स आ जाते हैं, वो ऑटोमेटिकली कस्टम डिपार्टमेंट सीज एंड डिस्ट्रॉय कर सकता है, उसमें किसी की कंप्लेन की भी नहीं जरूरत। सही है। सो देयर इज एन ओवरलैप इन 3 डिपार्टमेंट का, बट एससीसीपी से मैंने नहीं देखा कोई ओवरलैप है, ठीक है।
Thank you,
सो आई
sir.
होप आई आंसर्ड योर क्वेश्चन, एंड अगेन अ गुड क्वेश्चन। इस पे अगेन हमें पूरा एक वेबिनार रखना पड़ेगा देर, क्योंकि आजकल बहुत ये मीजान फूड्स और पेप्सी की बहुत ही हीटली कंटेस्टेड लिटिगेशन चल रही थी। वो अभी थोड़ा सा सेटल, मेरे ख्याल से वो ज्यादा ही होगा, उसमें कुछ मुझे लगता है देर आर सम कंफ्यूजन्स। वो हाई कोर्ट लाहौर ने कोशिश की क्लियर करने की। सो उसमें है ज्यूरिसडिक्शन का एक मेजर इशू है, वो आप बिल्कुल सही पहुंचे, बट एससीसीपी का मेरा नहीं ख्याल है। सही है। सो वो इंशाल्लाह वी विल हैव अनदर वेबिनार, उसमें आई विल ट्राई टू हैव प्रैक्टिसिंग लॉयर्स अपार्ट फ्रॉम मी, जो उस चीज को की सख्त रखते हैं, क्योंकि खाली मेरा इन आइसोलेटेड व्यू ना हो, बाकियों का भी हो। सो हम ज्यूरिसडिक्शन पे बिल्कुल डिस्कस कर सकते हैं जी।
If anyone else has any questions or if they would like to get some information from Mr. Salimi, you have the floor. Please go ahead.
Sir, given the current enforcement trends, what specific reforms do you believe are necessary to strengthen the enforcement of trademark laws in Pakistan?
यार देखो इसमें अहमद, इट्स गुड क्वेश्चन अहमद। पाकिस्तान में ना मैंने अभी जिस तरह स्टार्ट किया, हमें जो लिस्बन एग्रीमेंट है उस पे पार्टी बनना बहुत ज्यादा जरूरी होगा, और हमें बेसिकली जो मैड्रिड प्रोटोकॉल्स हैं, जिस तरह के मैंने स्टार्ट में बताया, आई होप हालिका, आमिना एंड ऑल द व्यूअर्स वर फॉलोइंग दैट, कि पाकिस्तानी प्रोडक्ट को इंटरनेशनली प्रोटेक्शन हासिल है, ठीक है। अगर कोई पाकिस्तानी ब्रांड है, उसने ट्रेडमार्क यहाँ ले लिया है, तो मैड्रिड प्रोटोकॉल्स में उसको प्रोटेक्शन है। बट इट्स नॉट वाइस वर्सा, जो मेंबर कंट्रीज हैं मैड्रिड प्रोटोकॉल्स की, उनको ऑटोमेटिकली पाकिस्तान में अभी प्रोटेक्शन नहीं है। उनको ट्रेडमार्क ऑर्डिनेंस के अंदर, इफ दे आर रियली वेल रिनाउंड ब्रांड्स, तो फिर उनको, और वही उनको शो करना पड़ता है, ठीक है। जिस तरह के फॉर इंस्टेंस आपका स्टारबक्स का एक केस था कराची में, बास्किन रॉबिन्स का मैंने ही केस किया था 2016 में। एक बेकरी है, वो इन्फ्रिंज कर रही थी, उन्होंने बास्किन रॉबिन्स का लोगो लगाया हुआ था और उनकी आइसक्रीम को लेबल कर रहे थे बड़ा बड़ा, जबकि दे वर नॉट एन ऑफिशियल आउटलेट ऑफ बास्किन रॉबिन्स। बास्किन रॉबिन्स अभी आ गई है ऑफिशियली लाहौर में एटलीस्ट, बाकी जगहों में भी शायद आ गई है मेजर सिटीज में। सो वो अगर आपको हमें कोर्ट में जाके प्रूफ करना पड़ा था इट इज एन इंटरनेशनली रिकग्नाइज्ड ब्रांड, और उसका एक टेस्ट होता है, फिर आप इन्फ्रिंजमेंट सूट करते हो, ठीक है। और फिर इन्फ्रिंजमेंट सूट और पासिंग ऑफ सूट करते हो आप, और फिर केस फाइल करते हो ट्राइब्यूनल में, और फिर जाके अगर आप प्रूव कर पाओ तो आपको इंटरिम रिलीफ, इंजंक्शन, सो ऑन एंड सो फोर्थ वो मिलता है। लेकिन अभी दिस इज नॉट हाउ बिजनेसमैन वर्क। आपको एक्सट्रपलेशन करते हो अपनी फ्यूचर की, आप देखते हो कि जी मेरा प्रोडक्ट है, प्रोटेक्टेड है, जिन जुरिस्डिक्शंस में मैंने एक्सपोर्ट करना है, क्या वहाँ प्रोटेक्शन है, वहाँ कॉस्ट अगर इन्फ्रिंजमेंट हो रही हो तो क्या प्रोटेक्शन है। सो इंटरनेशनल ब्रांड वुड आइडली वांट कि अगर पाकिस्तान ने मैड्रिड प्रोटोकॉल्स को का सिग्नेटरी बन गया है, तो व्हाई नॉट हमारा प्रोडक्ट भी पाकिस्तान में ऑटोमेटिक प्रोटेक्शन हो हमें, क्योंकि हर ब्रांड तो यार इंटरनेशनली प्रोटेक्ट वो फेमस नहीं होता ना, लाइक बास्किन रॉबिन्स और स्टारबक्स, ठीक है। सो उनकी ऑटोमेटिक प्रोटेक्शन हो तो बेहतर है। वो अभी अंडर द करंट स्कीम ऑफ थिंग्स, मुझे लगता है, माय ओपिनियन, दैट मैड्रिड प्रोटोकॉल्स में जो के बाद जो लेजिस्लेशंस करनी थी इंपॉर्टेंट, वो पाकिस्तान ने नहीं की। एंड सिंस पाकिस्तान, आई एम रिपीटिंग, इज ए स्टेट, ओनली वी, हम सिर्फ किसी एग्रीमेंट या किसी पार्ट सिग्नेटरी बन जाने से वो ऑटोमेटिकली चीज पाकिस्तान में इन्फोर्स नहीं होती, हमें उसके एवज एक कानून साजी करनी पड़ती है। सही है। यूके भी इसी तरह, इंडिया भी इसी तरह ही है, यूएस भी इसी तरह है, जो सिविल लॉ कंट्रीज हैं लाइक फ्रांस एंड अ फ्यू अदर्स, उधर ऑटोमेटिकली जब आपको इंटरनेशनल आप कन्वेंशन साइन कर देते हो तो ऑटोमेटिकली आपका वो लोकल लॉ का पार्ट बन जाए। सो आई होप आई आंसर्ड द क्वेश्चन।
Hello, sir.
जी
Okay. Sir,
जी
can you please tell me what strategies can be implemented in Pakistan to prevent future conflicts?
स्ट्रैटेजीज पाकिस्तान या कोई बिजनेस एंटिटी, जरा क्लैरिफाई करो।
Sorry, sir, can you please repeat it?
हाँ, आपका मैं I'm saying kindly clarify your question.
Sir, I'm saying what strategies can be implemented in Pakistan to prevent future conflicts,
Future
like
conflicts with
Starbucks and
what?
Starbucks?
अच्छा, लाइक स्टारबक्स। देखो, ये केस तो खैर अब पाकिस्तान बेसिकली, देखो, वी कैन मेक पाकिस्तान अ कंड्यूसिव एनवायरनमेंट इन टर्म्स ऑफ कमर्शियल एक्टिविटी। लोगों को क्लैरिटी हो, ये सिर्फ आईपी से नहीं ताल्लुक इस चीज का। आप लोग सारे बडिंग लॉयर्स हो, हम जब नया नया आज से 10-11 साल पहले जब लॉ में आए थे, एक बड़े फेमस हमारे जज हैं, अल्लाह उनको क़यामत में जगह अता फरमाए, जस्टिस फजल करीम, उनकी किताब है एक्सेस ऑफ जस्टिस, एक्सेस टू जस्टिस, सॉरी, एक्सेस टू जस्टिस इन पाकिस्तान। सो वो आप लोगों को मैं कहूँगा कि ज़रूर पढ़ो, ठीक है। वेरी एमिनेंट लीगल स्कॉलर एंड राइटर, आई थिंक वन ऑफ द बेस्ट बुक्स जो कि इंटरनेशनली कंपैटिबल हैं। उसमें स्टार्ट में ना, उसके जो प्रीफेस में एक बात लिखी हुई थी कि जी, किसी भी मुल्क में अगर आपने इन्वेस्टमेंट करनी है तो उसका लॉ अगर बेहतर होगा तो वो इंटरनेशनली लोग उधर आके इन्वेस्ट करेंगे और लोकल काम करेंगे। जब आपको लॉ का ही नहीं पता होगा और वो लॉ एग्जीक्यूटेबल ही नहीं होगा तो किसने क्या काम करना है? इट कांट बी अ पार्चमेंट राइट। कि पार्चमेंट राइट वो होता है कि कागज पे एक चीज लिखी हुई है, उसकी इम्प्लीमेंटेशन और एग्जीक्यूशन कोई नहीं है। सो उसमें पाकिस्तान को चाहिए कि हर चीज को थोड़ा एग्जीक्यूटेबल और वायबल बनाए, नॉट ओनली आईपी लॉ बट ऑल दी अदर मैकेनिज्म्स। उस पे एक्सपीडियंसी लेकर आए, कम्बरसम डिलेज हैं वो खत्म करें, और रिस्पॉन्सिबल करें लोगों को जो भी इस लीगल सिस्टम में है, ताकि फिर ये डिलेज और ये सारी चीजें ना हो। और वो गेन अगर, बिकॉज देखो, इट कांट ऑपरेट इन आइसोलेशन ना, आप सिस्टम के हिस्सा हो तो पूरे सिस्टम को में बेहतरी की बहुत जरूरी है। तो और इंक्रीमेंटली आप छोटी सी कोई चीज ठीक करेंगे, उसका बहुत आगे जाके बड़ा फायदा हो। सो आई वुड से दैट।
Okay,
So
sir.
I think we have very short time left. So I'll be asking the final
Can I
question. And
ask
if
another question?
anyone
Sorry.
else has any questions, they can ask it in the group, and then you can answer them at your earliest
जी,
convenience.
जी गिलानी भाई।
So, sir, my last question is on behalf of Mr. Waleed, who is partner of Khatana's Law Chamber Lahore office.
जबरदस्त।
Since he can't turn on his mic due to some technical issues,
जी
so
जी जी, मेरे सामने ही बैठे हुए हैं वलीद
जी,
साहब।
he
जी
wanted
जी
me to ask you कि ये जो एक Adidas वाला कुछ है ट्रेडमार्क का, I know the details, but if you could explain the case, और इस सिनेरियो में अगर like can you explain if such claims can be made
अच्छा, ये कोई
based on
2016 का
the
केस है। इसका एक पार्ट मुझे नजर आ रहा है जो शेयर हुआ हुआ है सिंध में, शायद ये सिंध हाई कोर्ट का केस है, इफ आई एम नॉट रॉन्ग। ठीक है, सो आपका एग्जैक्ट सवाल क्या है?
sir, my question is that if such claims are made or are brought over to the courts, how or to what extent can they be dealt under the trademark laws?
मैं समझ गया, मैं समझ गया। इसमें इशू ये था मेरे सामने। मैंने पहले, थैंक यू फॉर एजुकेटिंग मी, बहुत मजेदार ये चीज है, मैंने पहले नहीं देखी थी, मैंने अभी जस्ट गिव इट अ लुक। अच्छा, इसमें सीन ये है, एक फेयर यूज का ना डिफेंस होता है ट्रेडमार्क में। ठीक है, फेयर यूज ये होता है कि फॉर इंस्टेंस जिस तरह स्टारबक्स वाला केस था, स्टारबक्स कराची में कुछ लोगों ने स्टार्ट की, यंग लोगों ने अब्दुल सत्तार बख्श के नाम से कैफे स्टार्ट किए। स्टारबक्स ने उनको सू कर दिया क्योंकि उसका लोगो बहुत डिसेप्टिवली सिमिलर था। सितार बख्श की शक्ल थी, स्टारबक्स में मरमट बनी होती है, उसमें सितार बख्श एक बंदा था जिसकी इस तरह मूछें थी, और वही मरमट वाला स्टाइल और वही सारी चीजें थी। तो जब केस चला और स्टारबक्स ने कहा जी ये तो प्योर हमारी कॉपी है, सिर्फ कलर हल्का सा चेंज है, बाकी स्कीम और फोनेटिकली और होलिस्टिकली अगर देखा जाए जो टेस्ट होता है, आपने सिर्फ एक लफ्ज को नहीं पकड़ना होता, इस एडिडास वाले केस में भी वही था, आपने होलिस्टिकली देखना होता है। तो वो हाँ लग रहा है कि इन्फ्रिंजमेंट है। तो बेसिकली अब्दुल सत्तार बख्श ने एक डिफेंस रेज किया, एंड दैट डिफेंस वाज कि वी हैव नेम्ड स्टारबक्स आफ्टर आवर ग्रेट ग्रेट ग्रैंडफादर अब्दुल सत्तार बख्श, हु हैज बीन लिविंग इन दिस रीजन। और स्टारबक्स की कंसेप्शन से पहले से कि वो जिंदा थे, 1894 में उनकी पैदाइश थी, तो स्टारबक्स तो तब एग्जिस्ट भी नहीं करता था। तो ये फेयर यूज है और इट इज नॉट इन्फ्रिंजमेंट। इट वाज अ वेरी स्मार्ट पॉइंट। सो उस पे कोर्ट ने बेसिकली ये कहा कि यार अच्छा, लड़ाई आप ना करें, आप लोगों को थोड़ा सा चेंज कर दें और आप अपना भी कैफे चलाएं, सब कुछ करें, बट आप बिल्कुल जो सिमिलर आप लोगो है ये नहीं रख सकते, इसको थोड़ा सा चेंज कर दें। अब्दुल सत्तार बख्श बिल्कुल रखें आप, हम नाम को नहीं कुछ कहते, अगर आपके ग्रेट ग्रैंडफादर के नाम पे इट्स परफेक्टली फाइन। सो इसी केस में भी यही हुआ था जो वलीद साहब ने मेरे साथ शेयर किया है। एडिडास ने बेसिकली सू कर दिया कि जी आपने अपना ये ब्रांड आदि आदि पे ब्रांड बनाया हुआ है, अद्दी अद्दी पे और दास पे बनाया हुआ है। सिंधी में अद्दी बेसिकली बहन को कहते हैं, अद्दी बेसिकली कम्युनिटी को कहते हैं, ठीक है। इफ आई एम सो सॉरी इफ माय सिंधी पार्टिसिपेंट्स आर रेजिंग क्वेश्चंस के मैं सही ट्रांसलेट नहीं कर रहा। अब मेरे पास ये अभी अभी चीज आई है, ये मेरे सामने, मैं अभी आई एम रीडिंग इट फॉर द फर्स्ट टाइम। बेसिकली उन्होंने कहा कि अद्दी एंड और दास इज बेसिकली अ सिंधी वर्ड। तो हम सिंधी को हम ट्रांसलेट करके इंग्लिश में हमने ऐसे किया है, तो हमारा एडिडास से कोई लेना देना नहीं। हाँ, लेकिन अगर वो एक क्लोथिंग अपैरल ब्रांड होता है, इस सिचुएशन में आई डोंट थिंक सो इट वाज अ क्लोथिंग अपैरल ब्रांड, कैटेगरी क्लासिफिकेशन ही बिल्कुल फर्क है। सही है। सो उन्होंने कहा कि अगर हाँ वो क्लोथिंग ब्रांड होता अद्दी और दास के नाम से और वो एडिडास बन जाता है तो वो बिल्कुल इन्फ्रिंजमेंट होती, बट वो तो कैटेगरी बिल्कुल अलग है। और अद्दी बेसिकली एल्डर सिस्टर को कहते हैं और दास डिवोटी को कहते हैं, ठीक है। तो बड़ी बहन का डिवोटी ये कहना चाह रहे हैं अद्दी और दास। सो ये तो सिंधी में इसका बिल्कुल मतलब ही फर्क है और ये कैटेगरी ही बिल्कुल अलग है। सो इसलिए ये इन्फ्रिंजमेंट नहीं होगी। सो इट्स
व्हाट इफ अगर ये भी एक क्लोथिंग ब्रांड
आप करीब आ जाओ, आप करीब आ जाओ। सो
अगर ये भी एक क्लोथिंग ब्रांड ही होता।
हाँ, सो वलीद साहब ने बड़ा अच्छा क्वेश्चन रेज किया। वलीद साहब, अच्छा वलीद साहब चलें। वलीद साहब ने क्वेश्चन रेज किया है कि व्हाट इफ ये क्लोथिंग ब्रांड होता। अच्छा, अगर क्लोथिंग ब्रांड होता, सो माय नॉलेज बेसिकली एंड माय ट्रेनिंग इन इंटेलेक्चुअल प्रॉपर्टी राइट्स बेसिकली से 3 मिनट्स रह गए, आई विल ट्राई टू बेसिकली बी ब्रीफ ऑन इट। तो फिर ये इन्फ्रिंजमेंट हो सकती थी, लेकिन फेयर यूज इज अ डिफेंस। सो लेकिन अगर आप फेयरली बता, देखो एडिडास का अगर आप देखो, जैसा आपकी बैटरी का सिग्नल्स का आपका लोगो होता है, बार्स होती हैं आहिस्ता आहिस्ता इंक्रीज हो रही होती हैं, एडिडास का भी लोगो ऐसे ही है और एडिडास शॉर्ट फॉर्म में ऐसे लिखा होता है। तो वो होलिस्टिकली जो टेस्ट है इन्फ्रिंजमेंट का वो है कि डिसेप्टिवली सिमिलर, फोनेटिकली ओवरऑल जो आपका मार्क है वो सिमिलर नहीं होनी चाहिए। सो अगर आप खाली एडिडास यूज करो, स्टाइल फॉन्ट कंप्लीटली जो फेमस एडिडास उससे फर्क हो और उसका लोगो इसमें जैसा मैंने आपको बताया सिग्नल्स की बार की तरह है, ये थोड़ा सा फर्क हो, तो मेरा नहीं ख्याल ये इन्फ्रिंजमेंट है, क्योंकि ना इट इज फेयर यूज ऑफ अद्दी एंड दास, ठीक है। एंड अगेन ये जो मैंने आपको भी बैल्समिक विनेगर वाला और शैंपेन वाला भी केस था जीआई से रिलेटेड, उसमें भी इंटरनेशनल जूरिस्प्रूडेंस यही है कि आप इन आइसोलेशन किसी चीज को पिक नहीं कर सकते और कह सकते हैं इन्फ्रिंजमेंट है। आपने होलिस्टिकली एज ए होल फोनेटिकली उसको देखना है, स्टाइलिस्टिकली उसको देखना है, ठीक है। और मेरे पास एक्चुअली केसेस भी हैं जो कि मैं अभी ऑब्जेक्शंस जो हैं वो ओवररूल करवा रहा हूँ विद द आईपीओ डिपार्टमेंट, सिंस इट्स सब जुडिस, वो मैं डिस्कस उनके नाम नहीं ले सकता, बट आपने बहुत अच्छी एग्जांपल्स दी। सो अगेन अ वेरी गुड क्वेश्चन रोहित साहब, थैंक यू जी।
If no one
एनीथिंग
else has any questions, I would now like to thank Mr. Salimi for taking our time for this webinar. Thank you so much, sir, for your valuable insights on trademark law in Pakistan. Your presentation has greatly enhanced our understanding of current trends. So thank you very much.
थैंक यू जी,
I would
थैंक यू
also like to-
जी
Sir, please go ahead.
Ji, as a last note, I really want to thank you, Halika and Amina, to basically enable me to discuss this. So all the credit goes to you and Ahmed as well. क्योंकि आपकी अगर एडमिन टीम स्ट्रांग ना हो तो कुछ भी नहीं हो सकता है। सो ये सिर्फ आपकी वजह से ही है, मैं तो सिर्फ अपनी नॉलेज शेयर कर रहा था। एंड थैंक यू पार्टिसिपेंट्स, प्लीज आप अगले वेबिनार को भी अटेंड कीजिएगा। एंड इफ यू वांट टू स्पेसिफिकली डिस्कस समथिंग, सो प्लीज गिव योर फीडबैक इन द ग्रुप और बताइएगा आप अगले वेबिनार में क्या डिस्कस करना चाहते हैं इंटेलेक्चुअल प्रॉपर्टी राइट्स के हवाले से। साइबर सिक्योरिटी एक बहुत जबरदस्त एक रिकरिंग इशू है, पैटर्न थोड़ा सा टेक्निकल है, मैं उस पर भी कुछ चीजें डिस्कस करना चाहूंगा इफ माई पार्टिसिपेंट्स रियली वांटेड। सो थैंक यू वेरी मच।
Thank you for your time, sir. Take care.
थैंक यू, थैंक यू।